thank you for inviting me here to talk about not my own research necessarily, but the history of research on disparity and discrimination in sentencing from the eyes of scholars in the United States. And although I'm a political scientist by training, the first study that I did after graduate school was a study of the effect of race on sentencing. And so I've been involved in this area of research for many, many years, too many to count, actually. But it's something that's very close to my heart because I think that the issue of fairness and justice in the criminal justice system is critically important. And so what I'd like to do today is just kind of walk you through some of the evidence, both historical and contemporary evidence of disparity and discrimination in sentencing. And we often use those terms interchangeably, but they really mean something very different. And although we can identify disparities in sentencing, I'm not sure that we can yet conclude that those disparities are evidence of discrimination. I mean, some would argue that they are so glaring that there's no other explanation for them. So I'll provide some historical and contemporary evidence and then kind of walk you through the evolution of research on race and sentencing, talking about what I see as 5 different waves of research, and each of which has employed different methodologies, asked different questions, and evolved in some important ways. And then I'll end with a discussion of policy changes that we ought to consider if we're serious about reducing racial disparity and racial discrimination in punishment. So many of you may be familiar with Gunnar Myrdal's book, An American Dilemma, which was published in 1944. But Myrdal was an economics professor at the University of Stockholm who was asked by the Carnegie Foundation, or the Carnegie Corporation of New York, to undertake a, quote, comprehensive study of the Negro in the United States. Myrdal's examination of courts, sentences, and prison, which relied primarily on anecdotal evidence of disparate treatment of blacks and whites in the Southern criminal justice system, documented widespread racial discrimination in court processing and sentencing. Now, although all aspects of the criminal justice system came under attack, Myrdal reserved his harshest criticism for the differences in punishment imposed on similarly situated black and white offenders. He noted that grand juries routinely refused to indict whites who were charged with or accused of crimes against blacks, that whites who were indicted for crimes against blacks were rarely convicted, and that those who were convicted received the most lenient punishment. Myrdal also noted that crimes against other blacks, by blacks against other blacks, were not regarded as serious, and that therefore they too seldom resulted in indictment, conviction, or punishment. By contrast, Myrdal noted that blacks who were convicted of or even suspected of crimes against whites were subject to the harshest punishment. According to Myrdal, if the crime was serious and there was threat of a lynching, which was common in the United States in the 1920s and 30s, quote, "The court makes no pretense of justice. The Negro must be condemned, and usually condemned to death before the mob gets to him." Myrdal concluded his chapter on courts, sentences, and prison by stating that the whole judicial system of courts, sentences, and prisons in the South is overripe for reforms. And so let me just back up a bit and acknowledge that the United States has a very peculiar history with regard to issues of race and race relations, of course, with our history of slavery, and then with the Jim Crow laws that treated blacks very differently than whites, and then the civil rights movement. And so this has been an issue that has animated both policy discussions and research for quite some time in the United States. So Myrdal was describing the situation in the early part of the 20th century, and we know that much has changed since then. Supreme Court decisions protecting the rights of black citizens, even acknowledging that blacks were in fact citizens, coupled with policy changes adopted voluntarily at the state and federal level, have eliminated much of the overt discrimination that Myrdal cataloged in the southern United States in the early part of the 20th century. So, in contemporary times, blacks are no longer routinely denied bail, tried without attorneys to assist them in their defense, or convicted on scanty evidence. The level of opprobrium attached to crimes and the punishment dictated for those crimes no longer depends upon the race of the defendant or the race of the victim, and that wasn't always the case. In the United States, before the adoption of the 14th Amendment, which provided equal protection under the laws, many states had criminal codes that specifically differentiated in terms of punishment based on the race of the offender and the race of the victim. And this was particularly pronounced for the crime of sexual assault, but it was also found for some other crimes as well. So in the current era, we know that whites who commit crimes against blacks are not beyond the reach of the law, that blacks convicted or even suspected of crimes against whites do not receive justice at the hands of white lynch mobs. So as the 21st century unfolds, there is really little evidence of systematic and widespread discrimination against African Americans in the United States criminal justice system. But, and I think this is an important caveat to that conclusion, although most commentators would agree that the flagrant racism described by Myrdal in An American Dilemma has been eliminated, most also would agree that inequities persist in the American criminal justice system. Whether these inequities are due to explicit discrimination, implicit bias, or the implementation of policies and practices that have racially disparate effects, such as mandatory minimum sentences, the punishment imposed on blacks is often more severe than the punishment imposed on similarly situated white offenders. These inequities are particularly pronounced for drug offenses, and in the case of crimes involving white offenders and black victims, or excuse me, black offenders and white victims, in the case of the death penalty. And as a result, black men and women make up a disproportionate number of those who are locked up in our jails and prisons and who are on death row in the United States. So let's look at some of this evidence that supports this conclusion. One of the interesting things that I discovered while doing some research on this topic was a 1918 report by the Bureau of the Census on the, quote, Negro population in the United States. And the Bureau of the Census reported noted in its report that at this time, blacks made up only 11% of the population, but they made up 22% of the inmates of prisons, jails, and reform schools. And then the Bureau of the Census asked a question that has continued to spark controversy and debate throughout the 20th century and indeed into the 21st century. They asked, while these figures will probably be generally accepted as indicating that there is more criminality and lawbreaking among Negroes than among whites, and while that conclusion is probably justified by the facts, it is a question whether the difference may not be to some extent the result of discrimination in the treatment of white and Negro offenders on the part of the community and the courts. This is a question that was posed in 1918 and that 100 years later, nearly 100 years later, is still being asked. We're still asking whether the disproportionate number of blacks and now Hispanics who are locked up in our nation's prisons might be to some extent the result of discrimination. And I think the fact that it is still a question that is still being asked is due to the fact that the racial inequities documented by the Bureau of the Census in 1918 have actually worsened. They have not improved over time, they have worsened over time. So evidence of this comes from data that shows that, as I just mentioned, there were 22% of those locked up in prisons and jails in 1918 were black. By 1960, that had risen to 33%. In 1970, it was 40%. And by the mid-1990s, more than half of those locked up in state and federal prisons were African Americans. So in the years since the Census Bureau published its report, in other words, the percentage of blacks incarcerated in state and federal prisons had more than doubled. Because there were 11% of blacks in the population in 1918. Today, that number has not increased appreciably. It's about 13%. So where we had an 11% to 22% disparity in 1918, we now have a 13% to 50+% disparity. And so the obvious question is, why is that? Some additional data that illustrates this disparity. If we look at the race of persons admitted to state and federal prisons from 1926 to 1994, we see the same pattern. Blacks comprised 21% of people admitted to state and federal prisons in 1926. They made up 30% in 1950, 39% in 1970, 41% in 1980, and 44% in 1986. By 1990, blacks comprised more than half of all persons admitted to state and federal prisons in the United States. According to David Garland, who is one of the foremost experts on this topic, these statistics suggest, and I quote, the systematic imprisonment of whole groups of the population. There's other evidence that supports this conclusion. if we look at incarceration rates, that is the rate of incarceration per 100, the number of incarcerated per 100,000 population, we see that it was in 2012, 2,841 for black males, 1,158 for Hispanic males, and only 463 for white males. In other words, the incarceration rate for black males was 6 times the rate for white males. And although I haven't presented the data here, and the numbers are substantially smaller, the pattern is the same for for females. The rates range from 49 per 100,000 for white females to 64 for Hispanic females to 115 for black females. A report by the Pew Center for the States reported in 2008, and this was highly publicized, that this was the first time in the United States that 1 out of every 100 adults in the United States was behind bars. But what was even more startling about that report were the racial disparities, because when they broke it down by race, they discovered that it was 1 out of 106 white men, 1 of every 36 Hispanic men, and 1 of every 15 black men were behind bars. And for men between the ages of 20 and 34, it was an astonishing 1 of every 9. The Pew Center concluded that, quote, for Hispanic and black men, imprisonment is a far more persistent reality or prevalent reality than it is for white men.
And these are males?
Yes, that's correct. And just one more piece of evidence is the Sentencing Project, which is a nonprofit organization in the United States, published a report on life sentences and found that blacks made up 47% of those serving life sentences and 58% of those serving life without the possibility of parole sentences. And in fact, in 7 states, blacks made up 2/3 or more of those who were serving life without the possibility of parole sentences. And although I'm not going to talk about it in this presentation, if we looked at the proportions of blacks and whites on death row, those who have been sentenced to death, and in fact those who have been executed in the United States, we would see similar kinds of disproportionality. So the bottom line is that there is compelling historical and contemporary evidence of racial disparity in punishment in the United States. And so the question is, why? Why are blacks, and more recently Hispanics, so much more likely to find themselves in the arms of the law, and more importantly, to find themselves sentenced to prison for life sentences, sentenced to prison for life without the possibility of parole sentences, and sentenced to death? The patterns are all the same. They all show disparity in sentences for African Americans, and to a lesser extent, Hispanics. It's only been recently that we've turned our attention to the Hispanic minority in the United States, because until fairly recently, Hispanics were categorized as whites in much of our criminal justice data. So explanations for these racial disparities in imprisonment and indeed use of the death penalty are complex. But most scholars and commentators agree that a large portion of the disparity can be attributed to racial differences in offending patterns and criminal histories. That is, the fact that blacks are more likely than whites to be locked up in our nation's prison reflects the fact that they commit more serious crimes and have more serious criminal histories than whites do. Now, many of us would argue, well, they have more serious criminal histories because the police target them to begin with, and so they accumulate these criminal histories through stop and frisk policies that are racially discriminatory, targeting open-air drug markets where blacks are most likely to be selling and using drugs, and a variety of explanations like that. So probably the most oft-cited study looking at this issue is research that Al Bloomstein conducted and published in the 1980s and in the 1990s. And Bloomstein concluded using comparing arrests for serious crimes to incarceration for serious crimes and breaking those rates down by rate, he concluded that 80% of the racial disparity in imprisonment rates was due to racial differences in arrest rates for serious crimes. He replicated this about a decade later, and he came to the same conclusion. That is, using data for 1991, he concluded that 76% of the disparity was due to differences in arrest rates for serious crimes. Bloomstein's research has been criticized on a number of grounds, and perhaps during the Q&A we might talk about some of those criticisms. But I think the important point is that even if we look at Bloomstein's research, we find that not all of the racial disparity in incarceration rates can be explained away in this way. Even taking Bloomstein's very conservative estimates, we still would see that 20% of the disparity cannot be explained by differences in arrest rates. And in fact, when Bloomstein and others focus specifically on drug offenses, which is now the driving force behind the incarceration rate in the United States, they found that only 50% of the disparity in incarceration rates could be explained by differences in arrest rates between blacks and whites. So Bloomstein himself concluded that at least some of the, quote, other 20% might be due to racial discrimination or to the implementation of policies and practices that have racially disparate effects, including the war on drugs. And I don't really have time to go into a lot of the data on the war on drugs. But if we isolate offenders who are incarcerated for drug offenses, we see dramatic increases in arrest rates for blacks for drug offenses over time, and a concomitant increase in incarceration for blacks based on drug offenses. So I think the summary of this rather large body of research, Bloomstein started it. There's been several replications, several refinements of his work, not all of which has confirmed his conclusion. But nonetheless, I think most scholars would agree that some portion of the racial disproportionality in imprisonment rates is due to the fact that blacks are more likely than whites to be arrested for the very serious crimes that lead to imprisonment. I mean, the reality is we don't know if it's 80% or 75% or 50%, but most scholars would agree that at least some of this disparity is due to racial differences in offending patterns and also to racial differences in criminal histories. But I think we also have to acknowledge that the disparity also results, to some extent, to use the Census Bureau's terminology, from overt and/or implicit racial bias, and to the implementation of policies and practices that have racially disparate effects. And in that latter category, I would put the war on drugs, and I would put things like mandatory minimum sentences, 3 strikes and you're out sentencing policies, and truth in sentencing policies, all of which were widely embraced by states and the federal system during the so-called sentencing reform movement. And I put reform in quotation marks. So let me switch now from this evidence of racial disparity in sentencing, which is, I think, compelling. It's long-standing. It has worsened rather than gotten better. To talk about what I see as 5 waves of research. And for those of you who are sentencing scholars, you know that this has been a topic of research for at least 8 decades. And we now have literally hundreds of studies that look at judges' sentencing decisions and the degree to which those decisions are affected by legally irrelevant characteristics, including the race and ethnicity of the offender. Thorsten Selin concluded in one of the earliest studies of this nature in 1935 that equality before the law is a social fiction. And I think many of us doing research 8 decades later would make a similar, would reach a similar conclusion. So if we look at research over the past 8 decades, we see that the research has become more theoretically and more methodologically sophisticated. The questions that we ask have changed. When I started doing research in this area in the early 1980s, the question we asked was, does race matter? And I think that's a very theoretically unsophisticated question. We know that race matters. The more interesting question is, what are the circumstances under which and the context in which race matters? Because by answering that question, we can answer the question, why does race matter? And I think, I hope that is where research is going. Our analytical techniques have also improved. We've gone from very simple bivariate comparisons of the sentences imposed on black and white offenders to multivariate models, to hierarchical linear models, to efforts to model cumulative disadvantage over the life course of a criminal case. So our questions have become more interesting. The theoretical approaches that we bring to bear on these questions have become more, I guess, complicated. And the analytical techniques that we use to answer these questions have become more rigorous. If we go back to the first wave of research, which is studies that were conducted from the 1930s through the 1960s, these studies typically concluded that there were racial disparities in sentencing, and indeed that these disparities reflected racial discrimination. But these studies were almost all methodologically flawed, in that they failed to control adequately for the two most important predictors of sentencing decisions, and that is crime seriousness and the offender's criminal record. Many of them used very crude indicators of crime seriousness, controlling, for example, for whether it was a violent offense or a nonviolent offense. And many use very crude indicators of criminal history, looking at using just a dichotomous indicator of whether there was or was not a prior criminal record. And a review by Gary Kleck in 1981 of these Wave 1 studies, is that Wave? Concluded that the more adequate the control for crime seriousness and prior criminal record, the less likely it was that the study would conclude that there was racial discrimination, racial disparity, and thus racial discrimination. And so during the Wave 2 studies, which were published during the 1960s and 1970s, we saw the publication of more methodologically sophisticated research that generally found little, if any, evidence of direct racial discrimination. And these studies argued that discriminatory practices had been reduced, if not eliminated, in the wake of the civil rights movement that ensured political, social, and economic rights for all citizens in the United States, and that the bias that was found in the early studies was indeed due to inadequate controls for crime seriousness and criminal history. And many of the Wave 2 studies and those who reviewed these studies concluded, as did the National Research Council's Panel on Sentencing Research, which published a 2-volume report on sentencing in 1983, that there was no evidence of widespread or systematic racial discrimination in sentencing in the United States, that there were some pockets of discrimination for some kinds of crimes or for some types of offenders, but that discrimination was not pervasive in sentencing. The findings of studies conducted during Wave 3, which is research that was published in the 1970s and 1980s, suggested that these conclusions, this adoption of the no discrimination thesis, may have been premature. And many of the researchers publishing during this era argued that discrimination had not declined or disappeared. It had simply become more subtle and difficult to detect. And these researchers suggested that race affected sentence severity indirectly through its effects, not effects, but effects, on things such as pretrial status, type of attorney, providing evidence in other kinds of cases, and so on, or that race interacted with other variables to produce harsher sentences for some types of crimes in some types of settings and for some types of offenders. And so this, for example, is when researchers began to explore the interaction between the race of the offender and the race of the victim, finding in death penalty cases and in sexual assault cases that crimes by blacks against whites were singled out for the harshest treatment, and that there was substantial disparity, indeed discrimination, based on the race of the victim. And this is the time when researchers also began to show that it was the interaction between the race of the offender, the sex of the offender, the age of the offender, and the employment status of the offender that produced these disparate effects, so that research that Daryl Steffensmeyer and his colleagues did, and some research that I did, showed that it's young black and Hispanic males who were treated more harshly. And we actually showed that it was young black and Hispanic unemployed males who were singled out for the harshest treatment. And so I think these Wave 3 studies added an important dimension in that they showed that it's not sufficient to just say, is there a race effect, a direct race effect, but to ask a more nuanced question and attempt to tease out, again, the context or the circumstances in which race comes into play. So the Wave 4 studies, and this was research that was published from the mid-1980s through the mid-2000s, these were much more methodologically sophisticated studies, many of which began to use multinomial regression, multinomial logistic regression to look not just at the difference between going to prison and not, but looking at prison versus jail versus probation, looking at or using hierarchical models to see to what extent these disparities could be explained by the court in which the case was adjudicated or the jurisdiction in which the court was located. And there have been a number of reviews of these Wave 4 studies, and in 2000, I did a review for the National Institute of Justice that tried to, it wasn't a meta-analysis, it was a more qualitative kind of review of this research. So I reviewed 40 state and federal studies using data from the 1980s and 1990s, and I found that many of these studies indeed uncovered a direct race effect. That in both the state and federal studies, they showed that blacks and Hispanics were more likely than whites to be sentenced to prison. And in the federal system, these studies showed that blacks and Hispanics got longer sentences than whites. But I think what was even more interesting about this review is that it uncovered what I called 4 themes or patterns of racially disparate effects, so that the combination of race, ethnicity, and other legally irrelevant characteristics produced more disparity than race and ethnicity alone. Again, it's this young black male, young Hispanic male, young unemployed males, and so on. That race and ethnicity affected sentencing indirectly through effects on such things as pretrial detention, type of attorney, and so on. And I think the other 2 patterns got cut off, but the third one was that the race of the offender interacted with the race of the victim, as I've already said. And then the fourth was that race and ethnicity had particularly pronounced effects for some types of crimes. Drug offenses, death penalty cases, and less serious crimes where judges had more discretion to determine the appropriate sentence. So, although I think these Wave 4 studies moved us a long way in terms of both theoretical and methodological sophistication, they're not without their criticisms. And I think the most important criticism of all of the research that's been done to date, including studies, including my own, that were published during this Wave 4, is that these studies could not identify the mechanisms that produced racially disparate sentencing decisions. And I think this is the interesting question, and this is the challenge for sentencing researchers as we move forward, and that is, why are racial minorities sentenced more harshly than whites? Is it due to explicit or implicit bias? Or is it really due to sort of institutional discrimination based on the promulgation and implementation of policies and practices that harm racial minorities more than they harm whites? In addition, none of the research that's been conducted to date, or most of the research, can explain whether discrimination is found only at sentencing, because that's where we typically look, or whether discrimination is found at other stages of the process and accumulates over the life course of a criminal case. So are we only looking at the tip of the iceberg, as it were, by focusing on the final stages of the process? And shouldn't we be looking at those earlier stages and trying to estimate how disparity accumulates as cases move through the system? And finally, and we talked about this a bit this morning, the research really focuses on judges and assumes that the sentencing disparities that we see result from decisions made by judges, but I would argue that these disparities result from decisions made by prosecutors as well, and that we need to start trying to somehow tease out where the source of the disparities lies. So Eric Baumer, who wrote a review, a critique of the sentencing research that had been produced through 2012, argued, and again, some of this quote got cut off. He said that it would be highly beneficial if the next generation of scholars, and this is a challenge to some of you, delve deeper into the various ways that race matters across multiple stages of the criminal justice system. And I think scholars are only just beginning to tackle some of these issues. And so I think we're seeing the birth of what I would call Wave 5 studies, the next generation of research on sentencing, specifically focusing on racial discrimination in sentencing, and trying to answer these more interesting, these more nuanced questions. And I think I'm just going to skip over this and move on and talk about race, crime, and punishment in the 21st century, and a little bit on how we can extricate ourselves from the situation in which we now find ourselves, where half of those locked up in our prisons are African Americans. In 2004, the Sentencing Project issued a report on schools and prisons 50 years after Brown versus the Board of Education. And of course, Brown versus the Board of Education was a Supreme Court decision in which the court said that racial discrimination in the public schools was unconstitutional and that schools could not be segregated on the basis of race. And this 50 years after the Brown versus the Board of Education report concluded that whereas many institutions in the United States had become more diverse and more responsive to the needs of people of color, the American criminal justice system had, in their words, taken a giant step backward. And the report pointed out that there were 9 times as many blacks in prison or jail in 2004 as on the day that the Brown decision was announced in 1954. The number had grown from 98,000 to 884,500. I mean, the numbers are just astonishing when you think about it in those terms. And the report concluded that such an outcome should be shocking to all Americans. So, as we enter the second decade of the 21st century, we find that blacks, especially young black men, continue to be locked up in our nation's jails and in our nation's state and federal prisons in wildly disproportionate numbers to their representation in the population. Moreover, I think we all would agree that these disparities result to some extent from racial discrimination that's found at various points in our criminal justice system. So, what can be done to remedy this situation? Michael Tonry, who's a law professor at the University of Minnesota, argues that the most obvious solution, and the only one that will have a dramatic effect on the racial disproportionality, is to return incarceration rates to 1980 levels through decarceration. That is, Tonry argues that we should release offenders who have served a certain number of years. We know from research on the age crime curve that people age out of crime and that it has no deterrent or incapacitative effect to keep people in prison into their 50s, 60s, 70s, and 80s, as we do in the United States. And that going forward, we should send fewer to prison and for shorter lengths of time. There was just recently a National Research Council report on mass incarceration in the United States that concluded that locking up the shockingly high numbers of men and women as we do in the United States has had little deterrent effect on crime. Although crime rates have declined in the United States as incarceration rates have increased, this report concluded that the decline in crime could not be attributed to the increasing numbers of people who are locked up in our nation's prisons. So returning imprisonment rates to 1980 levels the black incarceration rate would fall from 2,661 to 827 per 100,000 population, and we would have 702,400 fewer African Americans locked up in our nation's prisons. This is probably not a politically palatable solution. Politicians don't want to be branded soft on crime, and releasing large numbers of offenders using this kind of policy or sending fewer offenders to prison probably would not win the support of the majority of politicians in the United States. But I think things are changing in the United States, and I'll talk about that in just a moment. But this is the only solution that would have a dramatic impact on the number of black Americans who are locked up in our nation's prisons. And of course, not only do these policies mean that large numbers, nearly 1 million black Americans are locked up, but then the collateral consequences of incarceration fall particularly hard on African Americans, their families, their children, and the communities in which they live. Many people who are convicted of a felony in the United States can no longer vote. And they can no longer get public housing. They can't get student loans. I mean, there are all kinds of collateral consequences that result from the policies that we pursued during the war on drugs and the war on crime. So how can we reduce the likelihood of incarceration and the length of sentences, which I think we must do in addition to this policy of decarceration? If we repeal or dramatically scale back mandatory minimum sentences, life without parole sentences, 3 strikes and you're out laws, and truth in sentencing laws.
What is 3 strikes and you're out?
3 strikes is it's a law that says once you're convicted of 3 felonies, you're going to go to prison for life, regardless of what those felonies are. Truth in sentencing laws are laws that require defendants sentenced to prison to serve a certain proportion of their sentence, the sentence that's imposed. In the federal system, it's 85%. So if you get a 20-year sentence, you serve 85% before you can be considered for release. In many states, it's 50%, 75%, or 85%. Making these policy changes would reduce what we refer to as the punitive bite of conviction for non-serious crimes. In the United States, many offenders who are convicted of possession of a certain amount of drugs go to prison for 10 years or 20 years, depending upon the amount of drugs, particularly at the federal level. Doing so would help bring U.S. incarceration rates in line with incarceration rates in other Western democracies. You've probably seen the graph which shows incarceration rates around the world. In the United States and Russia are at the top, and then everybody else, the graph goes like this. And so we're really the outliers worldwide in terms of the number of people that we lock up in our nation's prisons. And I haven't seen the most recent data, but I believe the United States is still winning that contest. And I think it will also, if we repeal or dramatically scale back some of these policies, it will reduce the racial disparities that result from the implementation of these policies. You know, for example, there's research on mandatory minimum penalties, which focuses on whether defendants who are eligible for mandatory minimums are charged with crimes that trigger mandatory minimums. So that's the discretion that the prosecutor has. So if a defendant commits a crime involving possession of a certain amount of drugs that carries a mandatory minimum sentence, the prosecutor can file the charge that triggers the mandatory or something less. And research shows that prosecutors are more likely to file those charges if the defendant is black or Hispanic. There's research in Florida on habitual offender laws, which are similar to 3 strikes and you're out laws, that shows that those laws are applied more frequently against black and Hispanic defendants. So if we get rid of some of these laws, we would reduce the racial disparities. And I think the time may be right in the United States to pursue these policy changes. Bruce Western wrote in 2006 that mass imprisonment is likely to be preserved by the political and economic forces that created it, and that policymakers and voters appear to retain a keen appetite for punishment. I think that this, in the last 2 or 3 years, has changed, and that Americans' appetite for punishment may actually be shrinking. Whether that's due to simple economic realities, in that we now spend more on corrections than we do on higher education in many states in the United States, or whether it's due to a recognition that this war on drugs and the war on crime has been ineffective. The Department of Justice, Eric Holder, the Attorney General, until they find his replacement, since he just resigned, has a Smart on Crime initiative where he has basically said we will no longer apply mandatory minimum sentences to drug offenders who are convicted of crimes involved in small amounts of drugs and who don't have substantial criminal histories. He's also said we need to use drug courts more often in the federal system. Congress is considering 2 pieces of legislation in 2014. I'm not sure that either of these will pass since it's an election year. But nonetheless, it seems that we're entering a new era of sentencing reform in the United States where politicians from both sides of the political spectrum, not just liberals, but conservatives as well, are saying that the time, that the war on crime and the war on drugs has produced nothing other than huge increases in our prison populations and huge increases in our correctional budgets, and that we need a more effective policy. We need, as Attorney General Holder said, a policy that is smart on crime, not simply tough on crime. And so I will conclude there, and I would be more than happy to answer any questions that you might have.
I have a question about the SB 1070 law in Arizona.
Yes.
To what extent do you think it increased racial discrimination scheme?
Well, if you talk to our sheriff, Sheriff Joe Arpaio, who's the one who organizes all of these raids that round up lots of illegal immigrants in Arizona, in Phoenix and other parts of Arizona, He would argue that, this has led to decreases in crime and made Arizona safer. Those of us who oppose those laws and those policies would argue that it results in racial profiling and that police and sheriff's deputies are using SB 1070 to round up and prosecute large numbers of Hispanic Americans who are committing no crimes other than being in the United States illegally. Many parts of that law have been struck down, but other parts have not, unfortunately.
Yes, I have a question about the interpretation of this, because, of course,
Do you introduce yourself?
yeah, sure. My name is
Even though most of us know.
Yeah, my name is Edward Tanner, and I work at the High School of Economics, and my interest is mostly comparative sociology. I have a question about the interpretation of these findings, because, of course, as a scholar who is focused on criminal justice, you tend to seek answers within the system, but maybe there is something larger going on, and we are talking about the failure of the integration effort in the United States. That may also have these two alternative interpretations. One of which is the failure of the policy, because the United States has tried hard for some time through policies of affirmative action and similar policies to change the situation. And maybe there is also something that is really beyond control of the governmental policies, and has to do, and excuse me if I go for a bit longer, has to do with the general, I would say, geopolitical situation, because one of the perhaps best prediction of the failure of the Soviet Union was done by Randall Collins, who is a professor of sociology at Penn State or University of Pennsylvania, who advanced the theory of geopolitical ethnic change. That is, a country was experiencing a geopolitical rise will easily integrate minorities because it's the identity, the state identity is prestigious, and people forget about their ethnic roots and they become Soviets or they become Americans.
Assimilated.
They become assimilated, right? But then, talking about the United States in particular, in the 50s that was really the case because Mexicans or blacks had no other way to go. It was, either you integrate or there was no other option. But then there was the Korean War, there was the Vietnam War, and all of a sudden you see a proliferation of minority movements, and people no longer wanted to be just Americans, they wanted to be Mexican Americans, Black Americans, and so on and so forth. So when you look at the dynamics of these very interesting figures that you presented, it seems like the bulk of the change really started in the 60s. And this is precisely the time when we observed these minority movements. And then, of course, after the Vietnam disaster, for a while, the situation was a little bit better to the Soviet collapse. But now that this euphoria has gone, faced with the basic fact that the American power is being diluted by the rise of the other countries, and people start no longer see the U.S. way as the only possible way. Therefore, they appreciate the American identity less, and they do not. There is an anti-American culture.
That's very interesting, and I just want to comment on your first part of what you said about economics, because I think what we don't do a very good job of in sentencing research, and this is why I found your research so fascinating on social class. Many critics of this body of research would argue that it's not race and ethnicity, it's class that's driving these differences. And of course, we know that blacks and Hispanics are much more likely than whites to be poor, to be unemployed, and to have all of the other markers of a lower social class situation. And so, the argument is, well, it's not really that criminal justice officials take race and ethnicity into account, but that it's some sort of class bias. And unfortunately, the data that we have in the United States is not very good at measuring social class. We record race and ethnicity pretty consistently, if not always correctly, but there's very little attempt to include indicators of social class in our data sets. The federal data, for example, does not indicate whether the offender is even unemployed or not, and it has income in the data set, but it's missing for most of the cases. So I think the explanation might be different. It might be that it's a class-based as opposed to a race or ethnicity-based kind of discrimination. There's also some really interesting research being done on sort of among African Americans, and this is research that psychologists are doing in the laboratory, where they give people pictures of African Americans and whites and Hispanics, and they find that those who have more of the facial characteristics of the, quote, typical African American are seen as more dangerous and more threatening and more likely to commit crimes. And so, I think we can't discard the racial discrimination explanation. Certainly not in the United States, where race continues to be an issue on the political agenda.
Of course, it is at least a part of the explanation.
A part.
But then, and I'm sure social class matters. But then there are channels of social mobility that are not being used because of this. For instance, in schools, this is an established term. There is an anti-school culture in certain neighborhoods in the United States because the term anti-American is no longer accepted, but anti-school is. So this is what's going on. This is not going. Another issue that I wanted to raise is how feasible it is politically to go through the steps that you suggested by repealing the longer. You seem to be optimistic, but I'm not sure about it. I judge simply. I follow up these events in Ferguson, and what politicians say, especially on the right in the Republican, doesn't bode well for this type of policies that you suggested.
Certainly, there are areas in the United States, there are politicians in the United States where these kinds of changes are totally politically unpalatable. But I guess I'm a glass full as opposed to glass empty kind of person, and you know, I see some of the changes, for example, to the stop and frisk policies in New York City, which I think would have been almost inconceivable 10 years ago, that we would have the sorts of changes that we're seeing now. You know, whether in 10 or 15 years and we look back and we see that some of these reforms were implemented, I don't know. I think that there's a growing consensus that mandatory minimum sentences serve no purpose, and that judges serve no purpose, and that judges must have discretion in deciding what the sentence should be.
And does motivation come from the fiscal reasons or other more noble reasons?
I suspect it's a combination, but I suspect that the fiscal reasons are what's driving it. I mean, when you have someone like Rand Paul from Kentucky, who is extremely conservative, arguing for the repeal of mandatory minimum sentences for drug offenses, I mean, I can't help but be a cynic and say that he's doing this because of the fiscal implications of mandatory minimum sentences.
It's an outlier.
Yes. Yes.
More questions or comments, whatever.
So this is not an issue in Russia, because
reducing the population.
No. The racial and ethnic bias.
Certainly not the racial bias, but I think ethnic bias is of course the issue, given the influx of migrant workers, with low education, poor Russian, for unprestigious job positions from Central Asia, and they create those ethnic differences and added elements which can be targeted, which are blamed in public discourse for the spread of crime. And our research does not really confirm this opinion. So they're not. Their crime patterns are not much different, even that they commit less crimes. They're treated a bit differently in courts, but the discourse, the public discourse itself, can lead to a shift in police policies, arrest policies, and judicial policies, and that's exactly the current research that we're doing. To what extent the recent anti-immigrant public discourse and some amendments to laws, whether it led or it didn't lead to actually the change in sentencing practices. This is one element. The second element is the problem of North-South in Russia. South is the Caucasus, but it's not the Caucasians that the way that you use it.
Right.
It's very, very different. My comparison would be the Russian Caucasus is the Sicily of Italy, right?
Oh, okay.
More or less. It's kind of very similar type of. It's more traditional kind of culture, more backward economically. In some ways, more violent, but in some ways much more disciplined. And again, lots of stereotypes. But we don't have data and ways of testing this type of bias. Unfortunately, but it may exist. No. We did actually. Kirill tried to test non-Russian surnames
Right.
and pretrial
Right.
detention, and they have some effects.
Mm-hmm.
They have some effects. I have. Are there any more questions?
I have a question. I was curious if there are any researches on how different generations of ethnical people from different ethnical origins are treated by criminal system, because it is there is an idea, especially in Europe, that the second generation is more dangerous than the immigrants themselves. So it would be interesting for me to know if there are any research on, maybe there is some research which studied this particular issue, framework, children framework, born America.
To my knowledge, there's no research that looks at whether someone is a first or second or third generation immigrant and the effect of that on the criminal justice system. I don't think judges would even know that, whether someone was recently arrived or has been in the United States for a long period of time. There is research, kind of going back to what you said about the perception in the United States and the perception among many law enforcement officers is that immigrants are responsible for a disproportionate share of crime in the United States. And there's a substantial amount of research that shows that that's not the case. But that if there is an immigrant effect, that it's typically the second or third generations where it appears. But I don't know of any research that looks at that with respect to sentencing. One of my doctoral students used the federal sentencing data to look at illegal immigrants who were prosecuted in the federal courts based on their country of origin, and found that those who came from Mexico were treated substantially harsher than those who came from the Caribbean or Puerto Rico or other South American countries. And so again, it's the stereotype that we have in the United States about those who immigrate from Mexico. Very negative stereotypes.
Rafi Rachitsky, sociology here at the European University. First of all, thanks so much for your talk. I'm not an expert. I'm not a criminologist, and so so my question definitely comes from an outside view, from more of a comparative, sociological, or historical perspective. I was wondering, the whole time you were speaking in this question of migrants and racial and ethnic minorities in Russia came up, I was considering the historical parallel of the Great Migration, the so-called Great Migration in the U.S., of when Black Americans moved from the mostly rural U.S. South to American cities in the mostly 1950s, 1960s, and maybe this coincides with various movements that later emerged, but definitely has a lot of considering not only the social justice movements that emerged around the civil rights movement later, but also beforehand, the ways in which maybe the criminal justice system might have been changing in cities and the way laws changed at that time, but also just the general understanding of who is a migrant and who is not from here, and who is other, and what that has to do with the way in which we even think about race or ethnicity, whichever way you want to approach the question. And maybe if you could tell us a little bit more about how that history, as a scholar of the way the laws were constructed during that time, might inform us a little bit about how can understand how those processes emerged to begin with in that second and third wave. So that's question number one. And just very briefly, question number two, just to tap on separately, if we have time later on, you mentioned a lot about cumulative disadvantage and how that research in the fourth wave was. How can we understand maybe the experiences of people who are impacted by these policies in terms of their various interactions earlier on as youth, as they grow up as children, and as youth in the criminal justice system, and how that might actually impact their attitudes towards school, towards the criminal justice system, and how that actually impacts their life chances where they end up. Thank you.
So I think I'll say a little bit about your second question first, because one of my colleagues, Nancy Rodriguez, and she's got a team of researchers who are looking at children of incarcerated parents, many of whom are minorities, and looking at the consequences of incarceration for those kids in terms of how they view the criminal justice system and their likelihood of getting involved in the criminal justice system down the road. And so I think that's really a very interesting topic. It's not something that I know much about, but I think there are some people who are addressing that. And certainly we know that children who are either abused or whose parents are involved in the criminal justice system have a much higher odds of being juvenile delinquents or adult criminals. But with respect to your first question about the migration of blacks from the South to the North, I think the critical criminologists would argue that the criminal justice system was used to control that so-called surplus population. If we look at some of the work of Austin Turk and Richard Chambliss, and I'm blanking on the person who did the social dynamite, they would argue that as unemployment among northern blacks increased and as competition for jobs and economic status increased, that the criminal justice system was the mechanism by which those populations were controlled. I think that's obviously, there's some validity to that argument. Because we see historically that incarceration, that things like lynching rates increase as political and economic and social competition increase, and that incarceration rates might follow the same kind of a pattern.
I think, unless there is some last very important question, I think our time is up. Thanks very much. It's a really very high quality and fascinating discussion.
Thank you. Thank you for inviting me.